Yeah, we're 14.
Okay, awesome. Just 1 second.
Well, you get to look at yourself up here.
Oh, yeah, I always say, check yourself, right?
Say it one more time. So good. I don't think they would move just.
All right, so Robert Klein, who's on that?
Put him up here.
Yes. Yes,
Sure.
yes, we're here on this clock. He has a motion to revoke.
Yes, Your Honor. I can let counsel lead the way if you'd like, counsel, but I believe, especially while we're kind of off the record to begin with, this is their client's third MTR. And I know that counsel, again, if I don't want to misstate anything, but I know you had previously put forth a motion to reduce bond, or I apologize, for early term.
Right.
So if you want to maybe just let the judge know what was maybe previously discussed.
The Honor would make clear to the state that the state had been given a CD with his medical records during the last 2 years. During those 2 years, he's amassed 1,200 pages of medical issues and problems. How many times have you been in the hospital for working on it?
8 times and about 15, 30.
15.
Yeah, and then I had a stroke.
He also had a stroke that affected his physical capacity. Mr. Klein has tried very hard to live up to 100% of the requirements, and he's not been able to because of, I'd say 90% or more, because of his medical conditions. He lost his left foot in an accident, and he's now asking the court under mercy, if there's not anything else, to let him stop the probation supervision. Robert, you want me to swear him, Judge?
Oh, well, just a second. So I'll let you swear him in if you want to have him give testimony. It's my understanding that he does have the medical issues. The court is aware of your medical issues, but here's the court's problem. One, I'm not going to consider early term or anything without the complainant being present. Number two, in the stipulations, the allegations that were in it that were stipulated to was that he went to her father's home, burned the grass with, it says here, the complainant provided her statement to me, because I see you're curious about what I'm reading. The statement can be located in the case folder. In her statement, the complainant describes her relationship with the suspect and described his escalating behavior, which included burning her father's front yard with gasoline and spelling the word BITCH with said gasoline. She also reported how her vehicle was tampered with. The decision to obtain the warrant came after I returned the following week to work and received a message from the complainant that the suspect had went to her work and was observed placing tacks under the complainant's tires. I also obtained a statement from the complainant's boss. The complainant provided several case numbers which document suspect's behavior. So I'm not going to consider allowing him to early term until the complainant is here to express whether or not she has any objections to early termination. And I'm also not going to consider early term because I realize that there are medical issues that may have occurred. But according to the motion to enter adjudication of guilt, there's a non-reporting in September, October, and November 2023. There's the consuming of alcoholic beverages. I'm not taking any of this is true, but it's alleged. On March 9, 2023, on the 22nd of March, 2023, an invalid sample for drug testing. April 6, 2023, another invalid sample for drug testing. May 19, 2023, invalid sample. June 23rd, 2023, invalid sample. And then there's a number 5, not reporting July and August of 2023, and I know that maybe that's medical. 9A, not reporting a change of address, job, or arrest within 48 hours. Then there's number 23, failure to complete intensive outpatient drug and alcohol treatment. And number 24, violation of the zero tolerance. So I'm not inclined to grant an early termination if the complainant is not present by Zoom, if nobody objects to Zoom, to give some input to the court.
Well, and Your Honor, just to make clear, counsel and I have spoken, and I, of course, the state is sympathetic to, when things happen to people of a medical nature. But the state did let counsel know that given the frequency of the MTRs in and of themselves, I believe this is the third,
Yes.
and the term of probation is due at the end, before the end of the year. The state would kind of respectfully not be in agreement with counsel for an early term as well.
Okay. So the court is not going to consider an early termination without that information. What we can do is, if he wants to enter pleas to the motion to revoke, he can enter pleas today, or either we can set it for a contested hearing. And I realize that it may or may not be a contested hearing. We'll just set it for a contested hearing. That'll give a chance for parties to bring in whatever information you all want the court to consider.
I don't think I'm speaking out of turn. Would the court consider, I don't know if the state, statement from the state, if they would consider a termination unchecked, but you go on with medical care and stuff, it still does the work.
Now, I want to hear from the complainant. Yes.
When's the next time you-
Oh, well, I'm sure the state has their contact information.
You want to give us a date yet?
Yes. All right, if you all want. Norma, are we able to bring this back on the 22nd or either in March? Oh, well, look, we're setting on the day he lost his leg and on the day of your daughters, your twins. All right, so March 5th?
Well, Judge, may I ask one clarification question?
Yes.
Sometimes, and of course, it's nothing to do with the party standing before you. In general terms, as the state, I may not give information, contact information, phone numbers of complainants, particularly those that have, been cooperative with the office in the past, and of course sought prosecution for the things that have happened to them. I'm more than happy, of course, to reach out to them. It's been a few years since we've had that contact. But if they indicate to me that same kind of willingness to cooperate and that same kind of almost happiness to kind of maybe not have anything to do with, the specific party, is it okay to relay that to counsel without sharing that information? Because I don't want to, I want to be as helpful as possible to the court and to counsel, but if she's still cooperative, I would maybe, I think, just be hesitant to relay any contact information over.
Oh, no, just have the person on March 5th. Defense, will you have any objection if they want to Zoom in?
Good. I'm certain that Mr. Bryan has had no contact with the baby, will not, and I will not provide him any information or means by which he could help.
Oh, I know you would not.
And even if the state, Your Honor, is still, if that complainant potentially, it's been so many years since we've spoken to her, but if they themselves have very strong thoughts on early term, and it may not be exactly what we anticipate, her testifying via Zoom or speaking to the court via Zoom is just add.
Just have her come in by Zoom, and then we will see what she says.
What she said. Okay,
Yes.
Judge, thank you.
All right, you're
Appreciate it.
welcome.
And just for the record, trying to understand if you are not to have any kind of contact, direct or indirect, with police. Yes, sir. You understand that contact with any
A month before I got, the one. We get overseas, almost 2 years.
Okay.
Thank you, Judge.
All right, you're welcome, Ms. Ferguson. Yes, Ms. Ferguson will give you a reset form that you can be excused. You're welcome. Thank you for coming down. You're welcome.